Chris. I am the postdoc at the faculty. And it is my great pleasure to introduce my good colleague, Dr. Sabine Jacques from the University of East Anglia. She's a lecturer in IP, IT, and media law. As some birds told me, probably senior lecturer soon enough, as the message goes. She's an expert on the parody exception copyright law, and we are very lucky to have her speak to us about this topic because her book on exactly that topic will be released in the next month, sometime.
Before Christmas.
Before Christmas, for Christmas presents. Without further ado, I leave the floor to Sabine.
Thank you very much, Chris, and thank you to all of you for being here today. Thanks to CIPIL for welcoming me here in Cambridge today. And as Chris rightly said, I will speak about the parody exception in copyright law. So let's get started. And for today's purposes, I would like to adopt the following structure. First of all, I would like to give a bit of background as to the introduction of the parody exception here in the UK. And this will really provide us with the context in which legislators decide to actually introduce a parody exception within copyright law. Then we will move on then to the obligations that are falling onto the national legislators and therefore the influence of the international copyright framework on how we frame a parody exception in copyright law. And then we will move on to the crux, really the substance of the parody exception. First, by looking at the purposes of parody, and we're going to try to define what parody actually means under the law. And after that, we will then move on to defining the outer limits, the contours of this parody exception for the purpose of copyright. And we will see that perhaps in order to deal with borderline cases, so cases where the parody is less obvious, we need to provide judges with more guidance, judges as well as right holders and users in order to know which type of use they are allowed to do under this exception. But the picture wouldn't be complete without actually studying the relationship between the parody exception, which is enshrined within the economic rights, with moral rights. So I will say a brief word on this before concluding. So, a short historical recap of the introduction of a parody exception in the UK. Parodies have been created throughout times and cultures. They actually embody a specific form of comment, and they fulfill an important function in democratic societies because they foster the development of arts as well as discord in society. Which means that in the early days, actually, these type of creative endeavors were granted a certain judicial latitude. With the evolution and the strengthening of exclusive right, we see that there is a shift towards a stronger protection of the exclusive rights and therefore a stricter approach to the infringement test, and especially the strengthening of the substantiality doctrine. So here we have a shift in the UK that can be represented by this case where we have Carry On Cleo, which is a loose parody of the movie Cleopatra. So this happened in roughly the mid-60s. And here we see that the judges apply the strict infringement test and say, well, clearly the defendant is producing a substantial part of the original work, and in the absence of a specific exception, this use should not be allowed. And this has been repeated following this particular case. So we see that this judicial latitude is then extinct. So the newly introduced parody exception in UK copyright law is actually the result of an extensive consultation. Although copyright law was completely overhauled by the CDPA in 1988, this was mostly before the advent of technologies as well as most EU harmonization. So with the Gowers Review reporting in 2006, there was this proposal of introducing a parody exception in order, amongst others, to better protect freedom of expression. And the IPO actually followed up, and there was 2 public consultations on this proposal, where most of the debate focused on whether there was a need or not to introduce this specific exception in copyright law, instead of focusing on what type of form the parody exception might take for the purpose of UK copyright law. Given that there was apparently insufficient evidence to introduce this change, we had to wait for a change of government and the Hargreave Review in order to see then another proposal for the introduction of a parody exception in UK copyright law. So Professor Hargreave was tasked with assessing how the existing intellectual property framework actually fosters economic growth as well as innovation in the UK. And reporting in 2011, he suggests and reaffirms that there is a need to introduce a parody exception in order to take advantages of the growing entertainment market worldwide, and especially that comedy, apparently, and I tend to agree, is a big business for the UK. So this is how in 2014 we see the entry into force of the parody exception, mainly in section 30A1 of the CIPIL, where we learn that there will be no infringement of copyright in a work where there is a fair dealing with the original work for the purposes of caricature, parody, and pastiche. But when a national legislator decides to introduce a new copyright exception to the reproduction right, he is not free to do what he actually wants. He needs to abide by the international obligation and the international copyright framework to which the country is party of. So in our case, the most important instrument is the 3-step test, which I'm sure you have somehow heard of. It's very well known. So it was initially introduced in the Berne Convention and then repeated in various treaties, such as the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. It was also repeated in the Information Society Directive, and some national legislators even decided to introduce this instrument within their national law, such as France. So what is this 3-step test? Well, at the time it aimed at recognizing the existing copyright exceptions that national countries had adopted, but also it serves as guidance to national legislator for future exceptions that they wish to introduce in their national law. So what are these 3 steps? First, the exception must be limited to certain special cases. Secondly, it should not conflict with the normal exploitation of the work. And thirdly, it should not unduly prejudice the interest of the author right holder, depending on which instrument you're relying upon. Where the debate has been mostly focusing, well, it's been linked to the interpretation of this test in the copyright framework, but also the role of this 3-step test in the Information Society Directive. Now, many commentators have discussed this, so I will mainly refer you to the works of Stanfleben, as well as Galopin, where basically the current situation seems to be that we're still unsettled as to why we have the repetition of the 3-step test in the Information Society Directive. Is it simply to remind national legislators of their international obligations, in which case the test might seem as redundant? Or does it mean that now this instrument, which is the result of a political compromise, is now directed to national judges that they would have to apply to particular cases? So in addition to applying the requirements attached to a copyright exception, they would have to ensure that these three steps are actually met in CASU as well. Which then brings a lot of problems, because it's quite unsettled as to how courts are adequately equipped to verify these three-step tests within particular cases. But also this might actually cause a problem in terms of harmonization of the exceptions within the European Union. So we're still waiting some clarification from the Court of Justice on this matter, and I will leave that debate there for today. But there is no doubt that when a national legislator wants to introduce a parody exception, for example, in their national copyright law, they must take into consideration this three-step test. And therefore, the form of the parody exception will generally be a result of these international obligations, as well as the legal tradition of a particular country. So, in my opinion, I think that most of the parody exceptions that I've been looking at have the potential to meet and to be compliant, therefore, with these three-step tests. Not only because we see that most legislators have actually elected a particular terms determining the purposes of the parody exception. So we have, for example, France and the UK looking at parody, pastiche and caricature. We have in Australia and Canada parody and satire. And in the US, this is left for the courts to decide, as we have these four fair use factors. When it comes to the shape of the exception in itself, well, we see that legislators have adopted these, like I will call them framework notions. So we have fair dealing in the UK, in Australia, and in Canada. We have fair use in the US, and we have the rules of the genre in France, which means that basically there are some factors that will help judges deciding as to whether a parody is lawful or not. Now, some reservations have emerged as to the compliance of the US fair use with its international obligation, given the fact that the latest cases seems to broaden the scope of fair use and to stretch it way beyond what would be allowed under these international obligations. This remains to be developed, but for example, there are some discussions as to whether the interpretation in Carey versus Prince, which I will come back on to, then doesn't jeopardize the compliance with the second step of the three-step test, and whether the abridged application of moral rights doesn't jeopardize the compliance with the third step of the three-step test. So let's break it down and let's have a look at first the purposes for the application of the parody exception in copyright law. And given that we don't have any definition as to what parody actually means, maybe we can learn from the different artistic fields as well as what cultural theorists have come up with throughout the years. Well, it's not going to be of much help because there are no agreed definitions as to what parody actually means. We do have the etymology of the term, which can be traced back to ancient Greece, but it only takes us so far as to understand that perhaps a parody is something that is beside the original work. So this is not really helpful for our purpose. So what can be derived then from the creative practices and the definitions that have been developed by cultural theorists, well, we have one consensus, is that parody embodies creativity. Great. But beyond that, there's no consensus whatsoever. So there are differences in terms of the target a parody should actually have. So it can vary from the underlying work, so the work the parody actually borrows from, or established artistic conventions or style, the author of the original work himself, the parodist, so these are called self-parody, or more generally, tradition, social values, and other political standpoints. The same is applicable for the nature of the borrowings. Here, the borrowings tend to vary from a particular work to a body of works, or more generally, styles and convention in a particular genre. There is also no indication as to how much we need to copy in order to have a successful parody. So it can actually be parts, so copying parts of another work, but it can also be copying an entire previous work. And even more puzzling, there's actually no consensus as to the functions of parody. So here the functions tend to vary depending on which cultural theorist you're actually referring to include either a comment or an homage, or to be more of a critical nature, or simply comical and entertaining. So these difficulties that we find in the various artistic fields are likely to actually be transferred to the legal sphere, and therefore are somewhat problematic for the application and the efficiency of the parody exception in copyright law. Indeed, none of the legislators for the countries that I've been studying have decided to adopt a statutory definition of what parody, satire, pastiche, or caricature actually means. And therefore, definitions are likely to be crafted on a case-by-case basis, as it has been the case for in statutory interpretation. So what do the statutory rules of interpretation actually indicate? Well, firstly, judges will consult dictionaries in order to try to understand the ordinary meaning of the terms. So that will be their starting point. But what we know as well is that this ordinary meaning can only constitute a starting point, and then you have to understand these different concepts within the purpose and the context of copyright law, of the exception. And when it comes to the parody exception, there is no denying that freedom of expression is one of the main drivers. The parody exception is a form of comment, and therefore its essential function is to preserve and promote the exercise of freedom of expression in a democratic society. So that might bring us to actually a situation where we're trying to understand what's the relationship between proprietary rights, versus freedom of expression. Should copyright prevail over freedom of expression? Or should we conceive freedom of expression as prevailing over copyright? If copyright prevails over freedom of expression, then that might lead us to a very limited scope for the parody exception. So it would be applicable only in limited cases. Whereas if we elevate freedom of expression as the driver and over copyright, then we might actually disrupt the balance that has been struck by legislators, and the fact that we have more of an owner-centric approach, because we say that we have a high level of protection of right holders. So perhaps the best way to conceive the relationship between copyright and freedom of expression actually rejects both of these approaches. And here I tend to agree with three scholars, Strowell, Tulkens, and Voorhoef, who argue that international and European provisions actually protecting freedom of expression are somewhat limited by copyright in particular cases. And what they mainly discuss is the fact that where you have a specific copyright exception, then judges can more easily accept and take into consideration freedom of expression arguments. So we know, for example, that because we have this principle of interpretation of high protection of exclusive rights and of right holders, judges have mainly refused to hear argument based solely on freedom of expression coming from defendants because they don't want to disrupt the balance struck by legislators. However, by enacting this particular parody exception, then we maintained this separation of powers between the legislative and the judicial branches, and we allow perhaps freedom of expression to be taken more into account in these type of cases within copyright law. But luckily, we start to already have the first application of the various parody exceptions in different countries. And therefore, we can start to have some guidance as to the meaning of these terms. The first case, and this is especially relevant for the EU, but we will see that its teaching actually goes beyond the EU territory, is the Dekmin case, as you probably have heard about. So here we have the Vlaams Belang Party. It's a Flemish national political party who distributed a leaflet during a New Year's Eve party, which substantially reproduces the comic book cover of Suske and Wiske. In this case, we're looking at the cover of The Compulsive Benefactor. And what has been altered here? Well, we see that the general feel of the original has been reproduced. The main character has been transformed into the mayor of the city of Kent, Mr. Termont. We have the colors of the Belgian flag. We have the other main characters of the comic book that are loosely reproduced. And we see that the mayor of the city of Kent seems to be distributing money to people from different ethnic backgrounds, whereas it's not the case in the original. So the message that was being conveyed here by the political party was that perhaps Mr. Termont, so the mayor of the city of Kent, was more worried about spending public funds on immigrants rather than other causes. So we can see that here the message could be actually discriminatory. So what did the Court of Justice actually establish? Well, it established that parody should be understood as an autonomous concept, so it should be understood in the same way throughout the EU territory, and it superimposed two main characteristics. Firstly, we need the parody to evoke the earlier work while being noticeably different from it. That's the first requirement. The second requirement is that it must constitute an expression of humor or mockery. This is basically how the Court of Justice has decided to define, in a way, parody, but it also added a third requirement, which is that national courts should carry out a proportionality test between the interest of right holders and the freedom of expression of users. And I will come back onto that in a minute. So, how can these two requirements actually help our national judges in applying the parody exception to specific cases? Well, in the UK, we have no cases to date. So we still don't know how the UK judges will understand and apply these two main requirements. There seems to have been mixed messages from the IPO and therefore from the guidance that is non-binding from the IPO, in the sense that sometimes it understands the three terms as being distinctive, one from another, and in the most recent guidance, it seems to be that parody should be understood as an umbrella that includes other related terms, such as caricature and pastiche. And this confusion actually led to a debate among scholars. For example, we have Emily Hudson, who argues that the three terms should be understood distinctively. So the three terms should have their own definition and are applicable to different activities. And in her paper, she argues that, for example, pastiche could be very far-reaching in scope because it would extend to activities such as mashups, fan fiction, sampling, collage, or other appropriation art forms. While I understand how attractive this solution might be, especially in order to add some flexibility and to adapt to new uses that are becoming more and more popular amongst users, I'm not sure this can be reconciled either with the UK legal tradition, the historical legal tradition, or with the understanding of Deckmin. So, for example, I would argue that understanding pastiche as being so far-reaching as including all these other activities is likely to jeopardize this balance struck by legislators between exclusive rights and the interest of users. And it is likely that pushing towards this direction actually would seem to create some kind of an English version of fair use in UK law, which has been rejected up until now. And Hudson actually acknowledges herself that understanding pastiche like this is likely to bring the UK closer to the US, and especially to the understanding of parody, such in the case Caillou versus Prince. However, even amongst US scholars, this decision has been heavily criticized for stretching the scope of fair use so broadly that it is likely to bring the US in jeopardy towards the second step of the three-step test, which is the impact on the normal exploitation of the original. But also, this understanding is likely to actually curtail the principle of strict interpretation that is currently prevailing in our law. So if this was the intent of the legislator, perhaps we need more of a public debate on this as well. And finally, we should not forget that the US can actually rely on a corpus of cases that has been developed over 150 years. Whereas the UK does not have this opportunity, so there would be more uncertainty as to the scope of the exception. But what I think Hudson is trying to argue is that perhaps Deckmin was merely interpreting the term parody and should not be understood as an umbrella concept that would include also pastiche and caricature. The problem is there are several arguments where I still think that this argument does not hold. For example, and this is the weakest of the arguments, the parody exception is well known amongst EU member states as such. We rarely refer to the parody exception as being the exception for the purposes of parody, pastiche, and caricature. So perhaps having this first case interpreting the parody exception and knowing this practice amongst member states, the Court of Justice would have taken the opportunity to actually say, well, careful, don't forget that you also have pastiche and caricature. But this is a weak argument. Secondly, let's not forget that the Court of Justice actually agreed with the opinion of the Advocate General on this matter, so on the definition of the parody exception. And here, even though the Court of Justice has not reproduced entirely the reasoning of the Advocate General, by expressively agreeing, well, it is likely that the Court of Justice also agreed with the reasoning in the opinion. And there, the opinion could not be clearer. The Advocate General actually says that for the purpose of copyright law, there is no need to actually distinguish parody, pastiche, and caricature. Finally, the Court of Justice, even though the first question, the first question referred to by the Belgian court referred to the parody exception, the summary of the facts by the Belgian court and by the Court of Justice referred to a caricature. So, if actually we were dealing with a caricature, why would the Court of Justice define parody if it was not to actually understand parody as an umbrella term, including other concepts, other related concepts as well? But we will see. The debate is still ongoing, and we will know more as the case law develops. But perhaps we can learn from other member states, such as France, where initially we also have this attempt at trying to distinguish the three terms. So very early on, we see that parody is actually understood very broadly, and is understood as a change of context. So we have the Peanuts case and Tarzoon case. The first one focuses on the Snoopy character that is being transposed into a mildly pornographic context, and the second one is roughly similar, the Tarzoon case, where Tarzan is also put in a mildly pornographic context, but is also depicted as an anti-hero, and it's supposed to comment upon the mass media at the time. So following these cases, which have this broad understanding of parody as even including simply a change of context, we have 12 trans, which has been decided by the Supreme Court, and which actually tries to separate the terms. But it does so in a very peculiar manner, because here the court says that a parody requires immediate identification of the earlier work, whereas caricature constitutes a mockery of a person or a character, and a pastiche comments on the style or the genre adopted by the original author. So it seems like the Supreme Court is trying to define the three terms in relation to its targets. And scholars have tried to rationalize this distinction of the terms. And so we have, for example, Desbois, who says that basically each term belongs to a different artistic field. Parody would be relevant for music, pastiche would be relevant for literature, and caricature for plastic arts. But what happened to the others artistic field? What happened then to motion pictures? Does that mean that the parody exception would not be applicable? So I have a hard time agreeing with these definitions as well. We also have Françon, who revisits both the earlier cases, so Peanuts versus Tarzoon, as well as Desbois' understanding of the three terms. But he seems to be conflating satires and parody and trying to generalize the definition too much to actually mean anything. But this perhaps belongs to a past debate, because we have the first application of the parody exception since the interpretation of this exception in the Deckman case. So this is the Koons case. And here we see that the Paris Tribunal actually wholeheartedly embrace the requirements set in Deckman. So a parody must constitute an expression of mockery or humor and must evoke the original while being noticeably different from it. In comparison with other countries, then what do we learn? Well, in the US, and so I'm going to start with the US, in early cases we have a broad understanding of the terms parody and satire. Actually, fair use was applicable to both. But this situation changed with the landmark decision in Campbell, where we have the Supreme Court, which paved the way towards a binary distinction between parodies, which would be which could be lawful because they require copying, whereas satire perhaps do not necessitate reproduction of the earlier work and therefore are less likely to be found lawful. But this distinction was then strengthened by later cases, though it seems to be slowly fading away. So we have another case involving Koons, whereby there seems to be now exceptions to this binary distinction. So even though in this case the court repeats a lot of the reasoning in Campbell, it seems to allow for exceptions and therefore situations where satires would be rendered lawful. In Canada and Australia, well, there seems to be a clear rejection of the US definition. So that's already something. We have in Canada Michelin and United versus Untied, which is the most recent decision in applying the parody exception since its introduction in Canada. If we have a look at previous cases before the introduction of the exception, well, we see that courts have tried to define what a parody actually constitutes. So in the Canada, we have Favreau. And here we learn that a parody normally involves the humorous imitation of the work of another writer, often exaggerated for purposes of criticism or comment. However, this definition seems to be limited to the facts at hand because it refers to literary work only, and so it might be best to actually set it aside now that we have the parody exception in copyright law. And funnily enough, in the first case, since the introduction of the parody exception, we see that the court actually adopted the requirements put forward by the Court of Justice in the Deckmin case, saying that actually these two requirements reflect the ordinary meaning of the term parody and satire. So it seems like even further than the EU territory, Deckmin is likely to have an influence. In Australia, we also have cases prior to the introduction of the parody exception, where again we see this discussion as to whether parody should be allowed as opposed to satire. So we see the influence of what was going on in the US. But perhaps, once again, we should set that aside because the legislator has clearly said that both parody and satire should be allowed by electing those terms as part of the provision. And we have the first case since the introduction of the parody exception in Australia as well, which involves Pokemons, as you can see. And interestingly, the judge decided not to define parody and said that, well, anyway, there's an overlap between the fairness factors and the dealing, and therefore we can deal with that when we come to the fairness factors themselves. So it's basically pushing this question to the first fairness factor dealing with the purpose of the use. So as you can see, in different countries we have different approaches, which already might mean that we have a different scope for the parody exception in copyright law. So this is the guidance that we have so far as to the purpose of the exception. Now, if we try to define really the contours of the exception, then we have to look at these notion frameworks, so either fair dealing, fair use, or the rules of the genre for France. Whether we agree or disagree, today a copyright exception procedurally acts as a defense, and we have mostly an owner-centric approach as to the interpretation of these factors. So if we look at the principle of interpretation, we do have this distinction between strict interpretation and users' right as developed in Canada. So in the EU, we know that exclusive rights have to be interpreted broadly, which means that exceptions should be interpreted strictly. However, strictly does not mean restrictively. If we have a look at cases such as the Painter case, which deals with the quotation exception, we see that basically because of its justification and its justification of the promotion of freedom of expression, we need to take that into consideration, and we need to ensure that the exception fulfills its purpose. So strict, yes, but not restrictive. In Canada, well, ever since CCH, we have this doctrine of users' rights. So this is an attempt to put actually the interest of users on equal footing with the exclusive rights of right holders. Which also means that we should have perhaps a broad interpretation of exception, at least of the purpose of the exception. But if we look at the first case since the introduction of the parody exception, we see that actually the court decided to still adopt a restrictive approach to the fairness factors. So whether the users' rights doctrine as established by the Supreme Court actually paved the way to the change that it was supposed to bring in Canadian copyright law, well, today it is still unsure. In the US, we seem to have a mix of a liberal and a restrictive approach to fair use, depending on which factor you're dealing with. So the first factor is generally approached in a liberal manner, whereas the other factors are approached in a more restrictive fashion. Right. So what are these factors that I've been talking about? Well, it seems like when we're looking at either fair dealing or rules of the genre, we have a two-step test. First, we look at the purpose of the dealing, which basically mean today that we need to take into consideration the two requirements set out in DECMIN. And then we have a list of other factors that are generally adopted by courts. And you can see from the slides that some appear very similar one to another. The difference is that judges are able to attribute the weight that they see fit to each of these factors. So, for example, in the UK, one of the most important factors is the use or purpose of the original, of the activity, the alleged infringing activity, and therefore whether, for example, and this includes, whether the defendant actually had a commercial intent. Also, market substitution is really important in the UK. But the effect on the market of the original is actually not that important in Canada, for example. However, the nature of the use will be more prominent in this balance and this assessment of fairness. In the US, we see that the amount borrowed when it comes to parody cases is less important than, once again, the effect on the market of the original. So it seems that some countries, such as the US and the UK, have a more economic approach to these fairness factors. And perhaps this is not the best way to apply the parody exception for the purpose of copyright. So what I would argue is that we adapt these fairness factors. So factors that are commonly applied in many countries, well, we know, for example, from the DECMIN case that we have the intent of the defendant, which is important, so whether there was this humorous or mockery expression present, and absence of confusion. That's what I call the second requirement set out in DECMIN. So it must evoke the original while being noticeably different from it. In order to help out and to establish whether this second requirement is actually satisfied based on the facts of the case, then we can have a look at the amount reproduced. If the amount reproduced is so important that there is actually very little comment, then that might tilt the balance in favor of the right holder rather than the user. The motives of the defendant, and here we see that freedom of expression actually tints the application of the fairness factors. We are allowed to have a commercial intent under the parody exception, but it depends how you actually make a profit. Are you selling items with your parody on it for the purposes of simply making money out of somebody else's effort? Or are you trying to sell a parody because it is your expression that you're actually trying to get profit from? Some factors that should have less importance for the application of the parody exception, well, the encroachment of upon the right holder's economic rights would be one, because simply it might be that the demand for the original is killed for legitimate purpose, for the criticism that is actually made by the parody. The alternatives to the dealing, well, whether a license could be obtained or not, should not play a role, because we see from practice that actually right holders tend to refuse to grant a license for the purposes of parody. And the resurgence of the three-step test. I'm not really sure it is adequate in this area either, simply because with the correct application of these two main requirements, it seems that the three-step test should be satisfied as well. What we know from the application of the parody exception so far is that there are some factors that should be set aside for its application, such as whether the parody itself is original under the copyright meaning, whether it only targets the original rather than making a comment on something else, whether it acknowledges the original, or whether it's attributable to someone else than the author of the original. That might help us for clear-cut parody cases, but it will only be adequate for some parodies and not all of them. For more below-the-line cases, perhaps further guidance can actually be derived from the human rights framework. And this is especially looking at the third part of DECMIN, which says that national courts should balance proportionally the fundamental rights involved in a particular case. Some additional factors would be, for example, the standing of the speaker. We know from the jurisprudence of the European Court of Human Rights that journalists, because of their important function in a democratic society, are more likely to be taken seriously than other speakers. Political, it's the same for politicians, sorry. However, comedians, well, people know that by hearing the work of a comedian, they're supposed to take it with a pinch of salt. Same goes for the type of the expressions. So we know that political expressions are more protected than purely commercial expressions. But the context is also extremely important, especially when we look at parody. So that should also help courts in deciding whether a use should be lawful or not. And finally, the content of the expression itself. So we should respect the fundamental rights of others, and the parody exception should not lead to abuses. So what about DECMIN? Well, by applying these factors, there are arguments to actually go either way. So we will have to wait a bit more. It should not be long now before we have the Belgian court deciding on this matter. But what if the original author actually wants to prevent these type of uses, or this one? Can actually moral rights be at the rescue of the interests of the original author? Well, we know that the parody exception is an exception to economic rights, and therefore it's not applicable to moral rights. And we know as well that this is an area where there is a different threshold amongst the countries, that I've been focusing on this. So there's a high level of difference in terms of level of protection. The most relevant right when it comes to parodies is likely to be the paternity and the integrity right. But perhaps it's not a problem after all, simply because the paternity right means that the original author should be identified with his work. But if we provide this identification requirement to parodies, then this actually might lead to a certain confusion, that there might be a link between the original author and the parodies. But also, given that the parody actually needs to evoke the original work, while being noticeably different from it, then it is actually likely to already be taken into consideration at that stage. So there might be a way to reconcile the two in this case. The same goes for integrity rights. We know that we need to adopt an objective approach to integrity rights. So we need to look at whether the honor and reputation of the original author is being harmed by the parody from an objective perspective. And perhaps if there's no confusion between the parody and the original work, then there can't really be a harm done to the reputation or the honor of the original author. Because I'm already out of time, I won't go into more depth on the moral rights issue, and I will only mention contract law for a second, because this is absolutely crucial in order to ensure the efficiency of the parody exception in copyright law. If we allow parties to circumvent the application of the parody exception in their contractual relationship, then perhaps the parodies will still not be able to be created after the introduction of a specific exception. In the UK, well, the situation is clear because the legislator actually provided in the statutory act that there is a mandatory character attached to the application of the parody exception. In France, US, and Australia, the situation is less clear. However, it seems to be, and this is mainly argued by Lucie Guibault, that a correct understanding and appreciation of the right to freedom of expression tilts the balance in favor of recognizing this mandatory character attached to the parody exception. So in conclusion, thank you for bearing with me. Is there a right to parody, really? Well, no, because the burden of proof still falls onto the shoulders of the defendant. There are several calls in order to stretch these exceptions further in order to balance the expansion of exclusive rights. For example, for many years now, Professor Huguenot has been arguing such, but perhaps because we don't seem to be there yet as to getting rid of the catalogue of exception in EU copyright law, a more holistic approach to the appraisal of the parody exception with reference to the human rights framework where appropriate could be preferred for the time being. So all of this is forthcoming in a book. If you're interested, I do have discount codes for you, so feel free to take a leaflet on your way out. And thank you very much for your attention.